Good morning, and I would like to take this opportunity, and I think it's the first time ever that this has been said in the Fairmont Waterfront Hotel. Welcome to the traditional territory of the Hwlitsum First Nation. This morning is an historic day for the Hwlitsum First Nation. They are here to announce a very important rights and title claim that has been filed in the Supreme Court of British Columbia, seeking confirmation of the Supreme Court of British Columbia of their Aboriginal rights and title that have been affirmed for well over 160 years in the province of British Columbia. I think it's very important for the public record to hear what was actually written the day that the chief's ancestors were murdered in Victoria by Governor Douglas's brother-in-law, Chief Justice Cameron. The Victoria Daily Chronicle wrote on July 4th, the day of the hanging, "3 men are to be hanged this morning for a murder which they did not commit, a murder which there is no pretense in either law or equity for saying that they committed. We have disgraced our humanity, our religion, our law, and our free constitution by staining our hands with innocent blood. We have dragged 3 defenseless Indians who cannot speak our language nor understand our forms of law to the slaughter. We have offered them a human sacrifice to our caprice, our judicial ignorance, our base expedience. We are hurrying fast down a course of illegality, which if we continue to pursue, will swamp our liberties. We have tortured and flogged alike witnesses and prisoners to obtain circumstantial evidence. We have garbled the law and curtailed forms of justice. We have dictated to jurors and disregarded the recommendations to mercy. The first shot was fired from the gunboat at the Indian village among the women and children. Then, and not until then, the Indians fired in the heat of their passion upon the assailants, and the boy Glidden fell dead upon the deck. Whether they understood the interpreter's demands or not matters not now. If words and law have any meaning, this was not murder. They were resisting not arrest, but a wanton destruction of all they held dear. Eventually, these 3 victims were taken prisoner and are said to have been flogged. Mockery of justice. First flogged, then brought up for trial, condemned and hanged. Such a tale of outrage needs no comment from us. Let us go as it is to that country where there are men more learned in the law, more tenacious of the liberty of the subject, whether he be white, black, or red, and who have the power to judge and the right to punish all concerned for this atrocious crime."
Good morning. I'd like to thank you all for coming out as well today. My name is it's Raymond Rocky Wilson, the elected and hereditary chief of the Hwlitsum First Nation. We have some very important issues to go over today, so just bear with me. I'm going to go fairly slowly because I say these are important. First of all, I want to state that the Hwlitsum First Nations members are inherent ancestral peoples of the Coast Salish Network on both the paternal and maternal sides. We are ancestral Indians under the Indian Act, so we go back to prior to European contact. We have never been diminished in our sovereignty by exercising federally delegated authority under the Indian Act. So we've never come under the umbrella of the Indian Act. We have never agreed to the extinguishment of any of our rights and title in any form of treaty, either prior to Confederation or after. We fully meet the test of Aboriginal title. The critical date is prior to 1846, as set out by Delgamook and Baker Lake. We meet the test of Aboriginal rights. The critical date is at the time of or prior to European contact in British Columbia. And so as far as those Aboriginal interests go, title and rights, we fully comply with those tests. When you look at our history and genealogy, you will see that we have always been here and did not, as Canada would suggest, simply fall out of the sky one day in the last 10 or 15 years. We have called this press conference in response to an extremely irresponsible editorial published in last week's Vancouver Sun, and we would like to clarify some issues. And I think, maybe more importantly, to request Prime Minister Harper to immediately address our concerns. Our serious dispute is not with private landowners or other First Nations, but with the Crown, Canada, and the province, in this case British Columbia, who have consistently hidden their heads in the sand and ignored what we have to say. Sitting Bull would have said they have no ears. Contrary to the fear-mongering by the newspaper, we are not attacking individuals or claiming private property. That being said, Prime Minister Harper and his ministers of ANC and Premier Clark and her minister of the Ministry of Aboriginal Relations and Reconciliation certainly need to be held accountable and fully responsible for ignoring our rights. We also wish to remind Premier Christy Clark and Prime Minister Harper that although they were busy apologizing for abusing our children and hanging our Chilcotin brothers, they have not apologized to Hwlitsum for the lynching of our chiefs in 1863 at a so-called trial that was rightly described by responsible journalists of the day as judicial murder. We take that very seriously. This torture and murder of our ancestors was the direct and intentional cause of our dispossession of our lands and the poverty our people suffer today. We are here today to request that Prime Minister Harper, one, accept full responsibility for the failure of his government to address our just concerns over the last 9 years of his stewardship of our lands and waters. And two, for him to appoint a special envoy to meet with us to immediately end the poverty that has been forced on us through the neglect of his government, to the complete discredit of Canada and British Columbia, whose economy is built on our backs, on land stolen from our grandparents and forefathers at gunpoint. Any injunctions granted to halt development, injunctions to halt the sale of our Aboriginal title lands in the form of Crown land or municipal land, and any disruption of the BC economy from this point forward will come as a direct result of Prime Minister Harper and Premier Clark's failing in their respective trust, fiduciary, and constitutional duties to us and treating us with basic respect required of them by law, and work in good faith to respect our rights and title. Contrary to the irresponsible suggestions that we are intentionally claiming land claimed by other First Nations, we are supportive of federal Indian bands attempting to obtain their Aboriginal rights and interests, including the Hwlitsum First Nation. What we are saying, however, is that we have Aboriginal title and rights interests as well, which are being extinguished through ignorance and a deliberate policy of simply pretending we don't exist by Canada, BC, and federally created Indian bands pretending that they can ignore our rights and title. They simply put on a blindfold, put a hand over the blindfold and say, "We can't see you because Prime Minister Harper's ANC minister has deliberately chosen not to recognize you as an Indian band." We are not a band. We are the sovereign descendants of the Hwlitsum tribe of Indians. The Sun's reference to being a tiny band ignores the fact that we are in excess of 250 members, are substantially larger than the Semiahmoo First Nation or the New Westminster Indian Band or First Nation, which has less than a dozen members. Surely it is not suggested that our inherent or constitutionally protected rights and title are to be minimized because we have more or less members than some Indian Act bands. Our existence, ancestral lands and title were recognized by Governor Douglas, Colonial Administrator Pemberton, and Chief Justice Cameron prior to Confederation, which rights and title have been repeatedly judicially confirmed all the way to the Supreme Court of Canada. Our genealogy was affirmed by the Supreme Court of Canada in the Sparrow and Matthias cases, and by Judge Sigurdsson of the Supreme Court of British Columbia, and subsequently by Deputy Acting Registrar of the Indian Registry, M.M. MacDonald, in 1999. These are all final decisions and are not subject to any appeal. Prime Minister Harper and Premier Clark's policy of simply ignoring us in the hope that we will go away is a direct and proximate cause of this litigation. Our village site at Hwlitsum predates 1846. Our occupation of this land and of our grandparents' and forefathers' lands in the Gulf Islands and at Stanley Park, or Hoi Hoi, and our right to the Squai dance is in our DNA. Again, it goes without saying that we do not attempt to say that other First Nations do not have rights. We have never said that. We call upon all the dispossessed grandchildren of the owners of Hoi Hoi Stanley Park to contact our lawyers and provide contact information or the name of their respective legal counsel. We are serious about seeking compensation from Canada as our trustee for the theft of our land at Hoi Hoi Stanley Park, the ongoing desecration of our burial grounds by the Canadian Navy, and seeking a return of our ancestral lands to our control, absent the administration of a Parks Board whose tenure we never agreed to nor accept. The provincial crown land at Brunswick Point was first stolen from us by preemption, and when our ancestors bought back what they could afford at the turn of the 20th century, this land was stolen again, this time by expropriation for a purpose that never transpired. The TFN Treaty Agreement expressly excluded these lands from the lands transferred to the TFN as reserve lands, and also expressly made them subject to any other rights affirmed to any other Aboriginal people that are adversely affected by the provision of the final agreement of the treaty. The Crown was aware that the UBCIC, the Union of British Columbia Indian Chiefs, by a resolution, affirmed its complete support for Hwlitsum to protect its Aboriginal title and rights to a full and complete consultation process that would accommodate Hwlitsum's Aboriginal title interest. Similarly, the Crown was aware that TFN, the Tsawwassen First Nation, and Hwlitsum signed a mutual protocol agreement providing mutual support for each other's pursuit of a just and honorable treaty, and yet the Crown, with full knowledge of our claims, deliberately entered into agreements to sell some of these lands within our traditional territory with absolutely no consultation. Interestingly, in last week's Sun paper, Mr. Plant, ex-Attorney General and current Tsawwassen First Nation legal counsel, confirmed that the TFN settlement agreement did not in any way impact upon the affirmed rights and title of Hwlitsum, and yet had we not commenced this action, the Crown would have transferred title to these lands without our knowledge or consent. We remind the Crown that its ability to sell any of the Brunswick lands is expressly subject to Hwlitsum's Aboriginal title. It is disheartening that Canada and BC have taken an adversarial approach. Prime Minister Harper and Premier Christy Clark have not only breached but stained the honour of the Crown and have refused to act in good faith as required by the law. The Crown's actions or inactions towards us are egregious and opportunistic, and not in strict keeping with its obligation to take a trust-like approach as opposed to an adversarial approach as directed by the Supreme Court of Canada in Guerin versus the Queen. All the facts of our claim are set out in our claim in the Supreme Court of British Columbia and are supported by thousands of pages of archival documents and decades of academic research. Anyone wishing a copy of our claim and any of the supporting affidavit material only need to contact our legal counsel's office, who will forward you the materials electronically. Finally, the Hwlitsum tribe of Indians, and we honor our ancestors, never agreed to surrender its sovereignty, rights and title over its land and waters. As the grandchildren of the Hwlitsum nation, the Hwlitsum won't surrender its sovereignty either.